This is a very recent case. It's an invasion of privacy case, and actually it was just decided in June of 2010. This is a very scary case. This is the City of Ontario versus Kwan. And this involved an employer search of text messages that an employee had sent to his girlfriend, who was actually happened to be married to another employee. This is what is commonly known as sexting. In this case, it was a public employer, however. The sexting was occurring on a city-issued pager. What the employer did was, through their phone company, they were charged and had to pay for certain minutes, or I guess it's in the texting context, it's numerical. They had to pay for each letter, and so they wanted to make sure that their employees were not having to pay for having to send additional work-related texts, and that their program was sufficient to meet their employees' needs. When they went on and they found an extraordinary number of text messages between this particular employee and another employee, they actually contacted the phone company and had them download all the text messages. For those of you who are thinking that text messages cannot be retrieved, you're wrong. They can be retrieved by the phone company, and they can date back to as long as the phone company keeps their records. In this particular case, when they went on, they found not only was this particular employee sending an exorbitant amount of text messages to this individual, but the employee was arguing that he had a reasonable expectation of privacy in the text messages that were sent on the pager. However, the court, without determining whether the employee had a reasonable expectation of privacy, in fact, the Supreme Court assumed that the employee did have a reasonable expectation of privacy, and in this particular case, because it was a city pager, felt that the city had a legitimate business interest in intercepting those text messages to determine whether they were providing reasonable services in the form of phone texting availability for their employees. It was a work-related purpose that the court found was sufficient. However, this case creates extreme problems when it comes to what policies actually say compared to the technology that you're currently using. This particular public employee only had policies related to email communications on work computers. Well, the invention of text messages created a whole different scenario, especially for those of you who provide phones to your employees. That may give you the right to search their phone logs. Now, it's always been the case where you can monitor somebody's phone at work, and you can actually see what numbers they're calling, and a lot of companies actually have access codes that you have to type in order to use the phone. But when you give somebody, an employee, a company-issued phone, that creates a whole other set of issues, and you need to make sure that your policies are adequately prepared for that type of new technology. Additionally, one of the problems in this case is that the public employer never monitored any of the phone messages or content, except in this case. So that led to whether they were being discriminatory against this particular individual and what their official versus unofficial policies are. Additionally, some supervisors were enforcing the overage use policy and some were not. So these employees argue that they were not on notice that they could be monitored and intercepted. The thing to remember about this case is that rapid changes in the dynamics of communication and information transmissions are evident not just in the technology itself, but what in society accepts as proper behavior. That's going to be important to you if you ever find yourself in litigation, because what a juror finds as proper, reasonable searches and seizures, and where they find that people should have a reasonable expectation of privacy will differ as technology advances. Many jurors probably would get on the stand and think, sure, I have a reasonable expectation of privacy in my pager issued by my employer, especially if I'm sending emails to friends. Well, that could influence, certainly, what the outcome of your trial is. I know we're running short on time, so there are some other cases that are in this presentation that I've cited for you that you're free to look at on your own if you want to. This Stengart case had novel questions about the extent to which an employee can expect privacy and confidentiality in emails with her attorney. She actually logged on to her personal private email through her company computer to send emails to her attorney about a discrimination claim and harassment claim that she was going to bring against her employer. The company then intercepted those emails once the employee was fired, and she returned her company-issued laptop. The company then hired an expert to create a forensic image of the laptop's hard drive, including the temporary internet files that she had created. Those files contained 7 or 8 emails that she had exchanged with her attorney. And the email said these emails are protected by attorney-client personal and confidential information and should only be used by the recipient. Well, the employer then used those emails in the subsequent litigation about the discrimination and harassment. The court found that even though she accessed her personal email through the work computer, she did have a reasonable expectation of privacy. And this case was actually exacerbated by the fact that the emails were actually to an attorney. So there was a attorney-client privilege that the court felt could not be waived. The employer was actually sanctioned for viewing for one and for using those particular emails. In the Blakely versus Continental Airlines case, the employer was found responsible for preventing harassment in the workplace or workplace-related settings when it related to an online form that Continental Airlines provided to its employees. Some of its employees were going on and venting and making inflammatory and derogatory statements about another employee and about specifically female pilots. The plaintiff filed a lawsuit alleging that the Continental Airlines should be responsible for those comments made by the employees because they sponsored this particular website. In this particular case, the big issue was whether Continental monitored that website, whether they restricted the website, and whether they knew or should have known of the harassment that was taking place on the website. And the court did find that the employer could be subject to liability for any kind of sexual harassment and or hostile work environment claims based on the employee's private blogging activities, especially if supervisors authorize or they author inappropriate comments about an employee, or if, in this case, Continental actually posted the website and allowed their employees to be on it. Continental also monitored and would kick people off if they were putting certain types of information on that particular blog. The court found that the employee could, in fact, be liable for what their employees are writing on that type of thing. In this particular case, Jackson versus Planko, the defendant asserted that it terminated the plaintiff because he violated the company's policies regarding internet use and that he posed a safety threat to its employees. The interesting thing about this case is the suit was actually for discrimination and retaliation because the plaintiff, Jackson, took medical leave for a heart condition. Well, the company actually asserted in defense that they had monitored his website activities and that they were firing him because he posed a safety threat. The safety threat was that he happened to view blocked pro-gun websites. And he actually owned several guns, of which many of his supervisors were aware. And the fact that he was viewing these pro-gun websites after he had been written up several times made them concerned. In this particular case, he had had performance issues anyway. The supervisor had already given him several disciplinary actions, and when they start to notice that he is viewing pro-gun websites, especially post-Virginia Tech shootings, they got concerned. They had a security IT person give a report of all the plaintiff's internet activities and all of the websites that he had viewed during work hours. In that particular case, the court found that it had a legitimate business reason for actually terminating the plaintiff. The interesting issue about this particular case is there's also a law out there called the Preservation and Protection of Right to Keep and Bear Arms in Motor Vehicles Act of 2008. I know you're thinking, what in the world does this have anything to do with us? Well, if you think about it, that particular statute provides that the status of a gun owner is not a protected class, but you cannot terminate or discriminate or expel a customer or invitee or employee for exercising their rights to keep and bear arms. That is an interesting issue, especially when this particular company says that they fired him because he was on pro-gun websites and that they knew that he actually had arms in his vehicle. The other issue of that, though, is if you learn about that kind of stuff as a human resources manager, do you have a right to be concerned about workplace violence? And if you know about it and don't do anything about it, what kind of liability does that place on you?